you need to update your estate planning documents because the way Michigan law is structured, your new spouse does not automatically become your healthcare proxy or your financial decision maker. I know that there are some states where that indeed does happen, but Michigan is not one of those states. So if you want your spouse to be your financial proxy or your medical decision maker, you need to go and update your estate plan documents to appoint him or her to that role. The potential consequences for your spouse would be, well, it all depends on what your estate plan documents were before you went into the marriage. If you didn't have anything, well, in that case, your spouse could be automatically added on as a beneficiary, but say you had a will or a trust set in place, well, those documents before you got married, and assuming you did this well before you got married and not in anticipation of you being married to your new spouse, then that spouse would be left with the recourse of potentially having to open a probate estate and getting what's referred to as an elective intestate share that they would have otherwise been entitled to, which if you had an estate plan going into this, your objective was to avoid going through probate. But because you failed to update it after this major life event, unfortunately, your estate is going to have to be open and probate will have to be used. You can reach me in my office by calling us up or at nick@dellenbuschryanlaw.com.